last week, I got this letter from the public defender's office, specifically Jennifer Onstent, the lead state training director, sent me a written typed letter, 4 pages, single-spaced in an envelope to our office address. And she complained about my use of those examples, and she informed me that I was mistaken on the law. In fact, this is the particular portion of her letter on that point. She writes to me, this is the head of training. This is the person who's in charge of training all of the public defenders in the entire state of Colorado. You think they handle many self-defense cases? She writes, your position that the police murders of Tamir Rice and Jordell Richardson and the shooting of an unnamed Hispanic child were justified because these children were holding toy guns is not just offensive, it is legally and morally untenable. Well, first I would point out, and it's rather shocking that I have to point this out to a lawyer, a defense lawyer, especially one in charge of training an entire state's public defenders department, that murder is a legal determination. These were certainly killings, but not all killings are murder. Some killings are justified. Not all killings are criminal. Some killings are non-criminal. And whether or not a crime, a killing is a murder, an unlawful killing, usually murder intentionally premeditated, is a determination of law that is not made by the head of training of the Public Defender's Office of Colorado. They're not murders until they've been adjudicated to be murders. Until then, in fact, the killings are legally presumed to be lawful, because everyone who might be charged with the crime of murder for these killings would be legally presumed to be innocent until proven guilty beyond a reasonable doubt. None of that happened in any of these cases. They weren't prosecuted for the reasons we're going to discuss. They certainly cannot be said to be murders. This is not legal analysis. This is emoting on these tragic deaths by the head of training of the Colorado Public Defender's Office. But could she be right? Could it be right that it's legally and morally untenable? My position that these killings were justified because the children involved, the victims of the shootings, were holding toy guns. Now, whether it's offensive, I will leave to others to determine. I don't do feelings here. I'm just a small town lawyer. Whether my position is morally untenable, I will leave to the legislature of the state of Colorado, because they write the actual laws, and presumably they think the laws they write are morally tenable. I guess the head of training of the Colorado Public Defender's Office believes the Colorado legislature's laws are morally untenable, as we'll see in a moment, because what I can address is whether my position that the killings here were justified because the children were holding toy guns is legally untenable. That's what I do. I do law. So let's take a look at Colorado law. And I'll tell you, I'll have to ask you to take me at my word, because I'm not going to go through 50 states worth of laws. The Colorado law is consistent with the laws in every other state in the nation, with Washington, D.C., with Puerto Rico, with Guam, with everywhere American law and legal principles for use of force are applied. But of course, I was speaking in Colorado to the Colorado Public Defender's Office, and I'm being critiqued on my legal position by the head of training, Jennifer Onstent, of the Colorado Public Defender's Office. So let's take a look at the law, shall we? Well, could this be like a recent change in the law that I'm claiming is the case? Nope. So that a defender can rely on the appearance of threat without there having to be an actual threat has been law in Colorado at least since 1910. This is a Colorado Supreme Court decision, Young v. People, and it reads, "It is fundamental that the law of self-defense, which is emphatically a law of necessity, involves the question of one's right to act upon appearances, even though such appearances may prove to have been deceptive. Also, the question of whether the danger is actual or only apparent," whoops. Sorry, folks, I was attempting to adjust my screen. Also, the question of whether the danger is actual or only apparent, and as well the fact that the actual danger is not necessary, in order to justify one acting in self-defense. Apparent necessity of well-grounded and of such a character as to appeal to a reasonable person under like conditions and circumstances as being sufficient to require action justifies the application of the doctrine of self-defense to the same extent as actual or real necessity. Now, I don't know. Maybe my position is legally untenable, Jennifer, but it would appear the Colorado Supreme Court agrees with me. Here's another Colorado Supreme Court decision from the year of my birth, People versus Lavoie. And that Colorado Supreme Court says a person assailed may act on appearances when a person has reasonable grounds for believing and does in fact believe, that's objective and subjective reasonableness, by the way, that danger of his being killed or of receiving great bodily harm is imminent. He may act on such appearances and defend himself even to the extent of taking human life when necessary, although it may turn out that the appearances were false, or although he may have been mistaken as to the extent of the real or actual danger. But you may be saying, Andrew, you're old. This decision from the year of your birth is old too. Maybe that's not current law in Colorado. Well, let's take a look at the current statute in Colorado, specifically the deadly force portion, paragraph 2 of Colorado Self-Defense Statute 18-1704. It reads, deadly physical force may be used only if a person reasonably believes a lesser degree of force is inadequate and the actor has reasonable ground to believe and does believe that he or another person is in imminent danger of being killed or of receiving great bodily injury. Does it say only if a person is in danger, imminent danger of being killed or receiving great bodily injury? Jennifer, head of training of the Colorado Public Defender's Office? Is that what the law says, that there has to be an actual threat? No, Jennifer. No, the Colorado statute says the actor has to reasonably have grounds to believe that he's facing an imminent danger of being killed. That's adequate for self-defense. And if the threat being presented is this on the left, which looks identical to the actual firearm on the right, who could say that it would not be reasonably perceived as an imminent threat of death? Jennifer. But that's just a statute. Jurors are not read statutes really when they go into deliberations. And of course, a prosecutor who would consider bringing charges in any of these shootings knows that eventually that they'd have to make their argument to a jury, and a jury will be given jury instructions. They will be told by the judge how to apply the law to the facts of the case. The facts of the case, of course, are this, right? So how would they apply the law to the facts of the case? Well, let's take a look at the jury instruction for Colorado on self-defense and what's required in terms of threat. And it just follows the statutory language, as many jury instructions do. And it reads, this is jury instruction H12. This is what the jury would be read by the judge. Use of deadly physical force, defense of person. The jury will be told that the defendant was legally authorized to use deadly physical force upon another person without first retreating if he had reasonable ground to believe, objective reasonableness, and did believe, subjective reasonableness, that he was in imminent danger of being killed. Does it say, is the jury told, Jennifer, that the defendant has to be in actual danger of being killed? No, Jennifer, it doesn't say that. It is sufficient if the defendant had a reasonable ground to believe that they were going to be killed. I would suggest that nobody faced with this facsimile pistol on the left would fail to have a reasonable belief that they were facing a real gun. And that's all that's required under the law in terms of the nature of the threat. It doesn't have to be real. It doesn't have to be actual. It only has to be reasonably perceived. So when Jennifer writes that my position that the killings of these 3 example cases, illustrative cases I presented at the trial on this subject, are legally untenable, what are we looking at here? We are looking at the head of training for the Colorado Public Defender's Office, who doesn't know the law of self-defense, which her public defenders will need to argue in court. She would tell her public defenders that if they had an indigent defendant who used deadly force against a mere apparent threat, a reasonably perceived threat, that indigent defendant, being represented by the public defender's office, would have no claim of self-defense because an appearance of threat is not enough. She would be wrong. But if she trains the Colorado public defenders that that's what the tenable law is, they will be unable to defend their indigent clients. And those indigent clients will be convicted at trial, or they'll be compelled to take a very unfavorable plea deal because the public defenders of Colorado would have been mistrained by Jennifer Onstent. And that's tragic, folks. I mean, I don't have any personal feelings about Jennifer Onstent, but I do have concerns for criminal defendants. That's why I do criminal defense, particularly indigent criminal defendants. My first job in the law was at a public defender's office. I provided this office of the Colorado State Public Defender with many thousands of dollars of pro bono legal consulting and expert witness testimony, and secured an acquittal for their client because I care. And it would be nice if the public defender's office cared. They say they care. Here's their mission statement. Let's see if I can pull this up, make it a little bigger. The mission. Let's see if I can make this easier to read. I think I can. Here we go. Mission. The mission of the Office of the State Public Defender is to defend and protect the rights, liberties, and dignity of those accused of crimes who cannot afford to retain counsel. We do so by providing constitutionally and statutorily mandated representation that is effective. Is Jennifer Onstent head of training of the Colorado Public Defender's Office? Is she providing training that is effective when she tells the public defenders of Colorado that the appearance of a threat being sufficient to justify defensive force is legally untenable? I would suggest she's not. And I wonder if anybody at the Colorado Public Defender's Office cares that their public defenders are being trained to such a level of incompetence at the peril, not of the public defenders. They don't lose anything if their clients get wrongly convicted. At the peril of the liberties, could be decades in prison if one of their indigent clients is wrongly convicted of murder because they've been mistrained by Jennifer Onstent, head of training of the Colorado Public Defender's Office. Those indigent defendants could spend the rest of their lives in a cage because their lawyers, their public defenders, were mistrained by Jennifer Onstent. Does the public defender's office care about that? Does the public defender, the head of the department, is appointed by the governor? Does the governor of Colorado care about indigent defendants in Colorado? Does the legislature care? Does the Colorado media care? It would be nice if someone cared about these indigent defendants. It would be nice if somebody did.